major too?
Yeah, I have no idea what all I remember is I got 1 day for trespassing. I passed out in somebody's ditch drunk in the country. I shouldn't have pled guilty to it.
All right, I'll let you withdraw your guilty plea if you want to.
Yeah, I want to do that, if that's possible.
You have a bond up, so rather than sentencing, it's going to be a pretrial, and you're not working.
Yeah.
So I'll appoint Mr. Steyer to represent you. But I'm going to make it a condition of your bond that you also get the assessment.
Okay.
Since you admitted, you just said on the record you passed out drunk in a ditch.
Yeah.
I think that warrants you getting at least an assessment for substance use.
It's just
That
that,
doesn't usually
Don't say
happen.
anything
You
else,
don't
Mike,
have a
sir.
problem. You don't usually wake up in a ditch, passed out drunk. I'm going to go out on a limb and say that. Okay, so bond continued with assessment from hometown. And let's move it up since we're going to do a pre-trial.
Your Honor, my next availability is the 27th.
Okay, what? '27th
Of June.
of June. Okay, well, we don't need to do it that quick. Let's do something. What do you got in July?
I'm available the 14th, 18th.
Let's do the 14th.
Okay.
At least move this up a week. All right, July 14th will be pre-trial. Allow him to withdraw his prior guilty plea since it was uncounseled, and he says he was under the influence at the time which he made that. Next hearing, July 14th, will be a pre-trial.
Thank you. Just wait out there for my copy. Please don't.
State of Ohio recalls Holly Wingate, CRD 24704.
Okay. Where are you getting the buprenorphine from?
From HHG,
Okay, from the hospitalist group?
yes.
Okay. All right, so that's appropriate. You shouldn't be smoking marijuana, though.
It's just the gummies, I just take it for my anxiety.
Okay, you got community service to do. Get me a report from the hospitalist
Okay,
and come back July 21st. Write this down. Yep. 7/21. 7/21, 9 o'clock is your next hearing.
Your Honor, I can start doing community service in Huntington now that, with this new job, I can do it up in the morning,
Where?
at, Facing Hunger.
Okay, is that the place you recruit?
Yeah,
Okay,
thank you.
you're welcome.
State of Ohio versus Raymond Wall, case number TRD 23530, A, B, and C. Raymond Wall.
Okay, Raymond Wall got arrested on a warrant and posted a bond, but he still didn't make it to court this morning, at least yet, so I'm going to notify Mr. Sowers who posted the bond by text that he failed to appear.
All right, this is your final warning. Y'all don't be quiet out here. You're interrupting court. I'm going to put all of you on top.
So we'll set a bond forfeiture hearing. July 7th.
State of Ohio versus Kimberly D. Trout, case number CRB 24252.
Name your Kimberly Trout,
Yes, sir.
and you were set for review on Friday, you weren't here then?
I was sick. I am so sorry, sir.
Okay. You've got fines and restitution paid and community services.
Yes, I was wanting to see if you can give me a little more time on that.
Can you pay anything? Well, see, you paid,
I paid $125 on it. I still owe $419. I'm hoping to have $200 paid July and $200 in August.
all right, I'll cancel any warrant.
Thank you.
Set your next hearing, July 21st, 9 o'clock.
Okay, and can you tell me what days to do community service? Because
Any day but Sunday. You can come here to court at 7:30 to do community service.
7:30 in the morning?
Yes, ma'am.
Okay, thank you.
You're welcome.
Thank you, sir. I'll be here.
Okay.
Your Honor, we're ready for some pre-trial.
Starting pretrial dockets, we need the lawyers, we want their cases heard, and you come into courtroom.
State of Ohio versus Christopher Reese, case number TRC 251229, A and B.
Good morning, Your Honor.
Good morning. This is Mr. McCown's case.
Yes, Your
Set
Honor.
for first pretrial.
Yes, Your Honor. After discussing it with Mr. Hill, first, there were some errors, I think, on the records showing that he has a prior within, and I'm working with the court to get that resolved, where it shows it as a conviction. That is absolutely not correct in this. So I don't know what Mr. Hill's position is going to be after that, but it looks like we're probably going to have end up having a contested hearing at some point.
All right, I'll recuse myself because I know Mr. Reese fairly well. Don't think it would be appropriate for me to handle the case, and we'll ask the Supreme Court to assign someone. My guess is going to be Judge Langfeld. That's who they've assigned the last couple of years. Every time we request one, but I have to make that decision.
Sure.
If I don't want him, I'll call up and say, we would like Judge Langfeld, then they won't send him.
It always works that way, Your Honor.
Used to be the opposite. They wanted us to tell them who we wanted. Now if we mention their name, that disqualifies them from being appointed, so.
They're from the government. They're here to help, Your Honor.
Okay. You're switching sides, aren't you, Mr. McCown? Sounds like.
No, Your Honor. I still believe in governmental overreach, especially when it comes to VI arrests.
Especially now.
That's correct, Your Honor.
Okay, so what, I would say a month or so out for all that to play out?
It'll be what it is. Typically, my recollection is, if Judge Lansfeld's going to be it, we did it by Zoom on, I think on an off day. And so, however, he wishes to do
Well,
that.
I like to set a date so it doesn't get lost.
Sure, I understand that.
And that way, we can always change it, but it keeps coming up on a docket to be dealt with. So give me a date toward the end of July that's good for you, and then if Judge Langenfeld wants to change it, he can change it.
We'll do the 25th of July. That'd be a Friday.
July 25th?
Sure.
Put it down for July 25th. The clerk will send in the request for assignment of a visiting judge, and then we'll let whoever that's assigned to take over after that. So July 25th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Joseph Green, case number CRB 2546, CRB 25226, CRC 24151, A, B, C, and D.
This is Mr. Stratton's case set for pretrial.
Got a letter for you, Your Honor. He's doing very well.
Yeah. I've got a report from RRS.
Yes.
It's a good report, good screens. I'm assuming how's the state want to handle this? It looks like there is still a, well, the ODI has been pled and sentenced, so we don't have to worry about sentencing. We've got these two other CRB case numbers that are
Yes.
pending. Are those things that are going to need to be resolved, or how does the state want to go forward?
The
It's getting
elect-
good reports on these counts.
The alleged victims, Summer McCoy, I don't know if she's here by chance today. Summer?
She's not here.
She had stated previously that she wanted for Mr. Green to be successful in treatment, and she wasn't interested in a conviction. So we don't have any reports of any further problems between them. At some point, whether this is the appropriate time or not, we would be moving to dismiss that case. However, there's also a resisting arrest charge, and we will be pursuing that, but because of the fact that Mr. Green has been successful so far in treatment, we're not looking to impose any jail time on him if he enters a guilty plea. So that's where we stand today. Probably would be okay to go ahead and do that today. If he were to plead to the resisting, we would dismiss the domestic violence. And then we would either recommend a sentence today or withhold sentencing until a later date.
We'll do that today, Your Honor. We'll plead guilty to the resisting.
Okay. So let's get the correct case procedure. The resisting is 25226. So we change the plea to guilty on that charge, Mr. Stratton?
Yes, Your Honor.
Mr. Green, do you agree with that?
Yes, sir.
You have a right to make a statement on the resisting if you want. Do you want to say anything?
No, sir.
Okay, I think what I'm going to do is just reserve on the sentencing on that.
Okay.
To see further how you do on your counseling. 2546 is the other case that's pending. Domestic violence. And the complaining party in that wanted to get treatment, which is what you're doing, so I'm going to go ahead and allow that to be nolly, which means dismissed with that, but with the right to refile. So if you relapse and totally mess up and start causing her a bunch of problems, I may allow the state to reinstate the case. Okay?
I understand, Your Honor.
Here's the other thing that I noticed. You had a prior OBI that you got a conviction on in 2024. You
Yeah.
got an order on that. You need to start working on, of course, I know right now, your sobriety is the main thing, but you got community service and other stuff.
Yeah, I'm starting a job tomorrow,
Okay.
so I'll start paying on that, and, is it 5 days community service?
Yes, sir.
Yeah, I'll get that in, Judge.
Where are you gonna be working?
It's called Circulou Health. It's, Circulou Health. It's, taking care of people with disabilities.
Okay. Where's that located?
It's, in Ironton.
All right, Mr. Stratton, about the 25th of July.
Oh, that'll work, Your Honor.
So July 25th. And we'll just put everything down for sentencing.
Yes.
Okay, you're doing good, keep it up.
Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Gregory S. Henry, case number CRB 25-293, CRB 25-322.
Mr. Stratton's case set for pretrial.
Your Honor, if it pleases the court, there was previously a case, a domestic violence charge from 2024 that was a felony, and it went to the grand jury and it was no bill. There was a protection order in that case. So when it was no billed, there was I guess the word didn't get out that the protection order had to be lifted. So when he was charged with this violation of protection order, it should not have still been a valid protection order. So we would ask to dismiss that charge.
And is that the basis of both of these? Because we actually I've got two, 322 and 293 case numbers, both 25 cases.
Yeah, one was set today, one was set for Fridays. We put them both today.
They're both based off the same protection order.
No.
No.
Well, let's see here. 293 is the violation of protection order that would be dismissed because of the fact that the protection order is no longer necessary or even valid because of the underlying charge for which it was a temporary protection order from a domestic violence charge. Now, the May 27th charge, which is 25-322, is a new domestic violence charge.
Okay, so it's still in.
Yes.
All right, so 25-293 is going to be nullified. The basis for the protection order had been dismissed before the case was filed. It'll be nullified, but will allow 25-322 is going to go forward. It's set. You want to deal with it today? It's set on the docket for June 20th.
We put it on today with the other case, and we'll just ask that it be reset for another date. I think the prosecutor needs to get hold of that alleged victim in that case to talk to her about it.
So as I understand, you're thinking we need to go further out than June 20th?
Yes, right.
State agree with that?
We're okay with that, Your Honor.
Okay, so we're probably maybe looking in July.
Yes.
What's good for you in July?
I've got 5 dates I cannot do in July. Busy month. You just let me. Any Friday. I've got a couple of jury trials in.
Fridays are good or bad?
Fridays are better.
How about the 11th? July 11th?
Yes. You say the 11th of July?
July 11th, yes.
Just 1 second, Your Honor. I apologize. Yes. Yeah, that'll work, Your Honor.
Okay, so I'm changing the pretrial on 25-322 from June 20th to July 11th. And that'll be at 10 a.m. July 11th.
Yes. Thank you.
You're welcome.
Good gentlemen.
State of Ohio versus Caleb J. Langdon, case number CRB 25251.
Your Honor, Mr. Langdon, he is at Lawrence County Recovery. We got a letter for you. He's doing very well there. He's also taking a parenting class there. He is actually in orientation right now for his new job at
Engines.
Engines, yes. So I asked that the court not punish him for that, and maybe we just reset it for another date since he's doing so well. And
We're not opposed to that, Your Honor.
Okay. And that sounds like it could be a pretty good job, so.
Yes.
You want to interfere with that? You want to make the 11th, same date, July 11th?
yes, we can do that.
All right, July 11th will be Mr. Langdon's next hearing at 10 o'clock for pretrial.
Thank you. Thank you. Good to see you.
State of Ohio versus Michael Tilly Jr., case number CRB 24437.
Your Honor, may we recall this case?
Okay,
Yes.
Mr. Tilley's case will be recalled later in the night.
State of Ohio versus Katie Whitley, case number CRB 22767, CRB 22456.
Your Honor, I spoke to Ms. Whitley this morning. She's had some child care issues. She said she couldn't make it today, so I told her the next best option is to be here Friday then. So she says she'll be here Friday.
Mr. Hill?
Well, she's gonna be-
Continue to Friday or start the clock on a warrant.
That's what I would, for a warrant in 7 days if she's not.
Then if she shows up, she'll be.
Right, so you got 7 days to appear before warrant issues.
State of Ohio versus Trevor Dement, case number CRA 25309, CRB 25311A and B, CRB 24344, CRA 23380, CRB 21167, CRA 2321, CRB 2322.
All right, Mr. Dement is at Shawnee Council, Portsmouth, and Mr. Stires to the council.
Your Honor, we have a positive report here. We're still early, obviously, so I would assume the state and court are going to want to come back on this. In the meantime, Mr. Dement has asked that I inquire about removing his ankle monitor. Apparently, the folks at Shawnee are going to be going to Kings Island this weekend. He'd like to participate in that, and I think the ankle monitor may not allow that.
What says the folks at Shawnee to raise them off?
I told Trevor that I wouldn't be recommending his ankle monitor to come off, just for the simple fact that it's nothing that he's done. He's been compliant, he's done really well. I've just never recommended for one to come off before a month. But, you know, totally up to you. We are going to Kings Island on Sunday, and I'm going to request that he's able to go with us.
Yeah, I guess his ankle monitor, and we could use the ankle monitor because we got several in jail waiting on an ankle monitor. So, and here's the thing with Trevor. He's never going to leave Lawrence County. Are you? I mean,
No,
you'll
except to
away
go
for a little while.
to Kings Island.
Well, Kings Island, but I mean, he always comes back, even if he does a bunch of crazy stuff.
Yes,
He's got to come back there, we're going to have you.
yeah, I'll get caught.
You're going to wind up in the jail. It's not like you're going to move to California and we'll never see you again. That ain't going to happen. He's a Lawrence County in through and through, it's in his blood. So I'm going to take the ankle monitor off. Go see Mr. Major about that. But it doesn't mean you can go hang out with whoever gets you back to the things you know you should be avoiding. Understand?
Yes, sir.
You know what you need to do. You just got to do it. Okay, so see Mr. Major. We'll do an order removing the ankle monitor, and that somebody that's sitting in jail then can get out and start treatment because they got an ankle monitor available. You keep doing what you need to do. You know how to do it. You know how to stay clean.
Yes, sir.
You just got to make the right decisions when the time comes. So I want to see you back. Let's not wait a month.
I'm here the 27th, and I'm here the 14th.
Let's do the 14th. July 14th will be the next hearing.
Thank you, Your Honor.
Thank you.
You're welcome.
State of Ohio versus Adrian Price, case number CRB 2557, and CRB 24693.
Okay, Mr. Smith?
Yes, sir.
Counsel for Adria Price. We had conference in chambers Friday after court. I actually got some good direction from Mary Beth Pollard from Appalachian Behavioral, which got us in touch with the right people to have Ms. Price evaluated for some immediate psychiatric treatment which she needs. I thought about this a lot over the weekend, which she was pink slipped, and I don't know which hospital she's in, but she's been hospitalized. The problem's going to come, and we need to call again, as I understand it. There's still not going to be a long-term solution here, because our county does not have in place any kind of system for appointment of a guardian or for someone who is in her circumstance, as I understand it. If you're not over like 65 years of age, the Department of Human Services won't take any action, even though you desperately need it. Adria, just say that I don't think it's disputed. She had a conservator before, it was her mother. Her mother is in now, has mental health issues, and she's confined.
Yeah, that was terminated in April, Judge.
There's really no, she can't live on her own. She needs help. She needs someone to be there, take care of her business for her, keep her on lines of what she's supposed to be doing, and there's nothing here for that. So what are we going to do when she gets out of the psychiatric hospital? That's going to be the issue. What happens then?
If she is in one of the state mental health facilities and the period of time for restoration expires, typically they will, the hospital itself will seek a hospitalization by court order from the probate court in that county. So if it's
Well,
an
I'm not sure that's going to apply here, but that's something we'll need to discuss with Mary Beth Pollard, because she sent me an email back. The problem is going to be the recommendation from Southern Ohio Forensic was she was not restorable. So, and on a misdemeanor, I don't think they can keep her. It can only be dismissed then.
Well, it can be, the criminal charge can be dismissed, but it can be a civil.
Yeah, who's going to take that up? Our county won't do it.
The county where she's hospitalized typically does. In Athens County.
Athens will. I don't know if she's going to be in Athens.
Well, then I guess we'll have to cross the bridge when we get to it. But.
Yeah, but I see that as the problem. So anyway, to keep things moving, my suggestion today is just set another date, but then I think we need to do another phone conference after court today with Mary Beth Pollard and discuss with her what has occurred. But from our previous conversation, I don't think they're going to take her here because the mother is there. I think she saw that as a conflict, so she's going to go somewhere else. I think probably is somewhere else right now, but we don't know that yet. So maybe 2 weeks out, Mr. Smith, or so?
Yes, Judge, I'm here. Probably the 27th is the best. Then I start hitting the jury trial. Is that a good date?
Yeah.
Okay.
It's not 2 weeks, but it's close enough.
Okay.
June 27th will be the next hearing. Then I do want to see counsel after court to make another conference call to Athens.
Hey, Judge, may I say something?
Yes, sir.
Also, the house next door has been woefully neglected. It's grass, pools full of bad looking water. It's a mosquito infested place. I've heard that the dog was in the house for over 2 weeks and had to use the defecated in the house. And it's a bad situation.
Yeah, and we just don't have much tools to deal with that. So I don't know. There's no family here that has any interest in, but obviously there's property. I don't know the situation, if it has a mortgage or lien on it, or, there should be some solution to this. There should be some agency that will step in and take some charge here, but I don't think there is.
Can I add something else?
Yes, sir.
Yes, we did look it up. There is a trust on the house, and Vicki was named as the trustee.
Okay.
And there's a second trustee, the City National Bank in Huntington.
Okay, well, thank you for that, because that's, they do have, City National does have a trust department, and I know the people there, and that's somebody we can contact and maybe at least get some help with regard to managing the property.
I did stop by there myself and talk to them, and I told him about what's going on, and he knew you, and it might be a good idea.
Okay, so maybe, that may be probably not a solution for getting her care taken care of, but at least getting the property taken care of. I'm assuming there must be some other assets in the trust from which they could pay for cutting the grass and take care of the pool and taxes and whatever. And eventually, I don't know what would happen to the property, but something has to be done with it.
Yes, sir.
Okay, so we'll look into that too. Thank you.
The only issue, I have a 1 o'clock in Huntington, but I think the dock is going pretty quick, so that shouldn't be a problem.
Except for the jail. People were not.
Well, yeah, I forgot about the jail.
Full of
Yeah.
people.
Right.
Okay, thank you, sir.
Thank you.
State of Ohio versus Thomas Lewis, case number CRB 24751, CRB 24791. Your Honor, I was handed this morning, and my clerk said that there was some type of a motion. I'm not sure if it's going to change.
Mr. Smith, this is your case.
Oh, I didn't see it on, I'm sorry, Judge.
It was just added.
Oh, okay.
It's my understanding there was a motion to modify protection order or something to that effect.
Yes. Is she still a minor?
She is it's the daughter, right? Is she here today?
Yes, she's here. She's
Okay.
coming in.
Yeah, I see him coming through the door.
All right, let's have him come in.
Okay. Well, that's good.
Yes, I'm sorry. I want to cancel him.
That's good news.
Okay, this is the minor with initials TL.
Yes, Your Honor.
She's present in court with her mother.
And she's asked to dismiss the protection order because she wants to do counseling with her father.
Restore the relationship.
Okay,
Restore the relationship.
He wants to do that, Judge.
and I think that's good. I applaud that. So that'll be granted. I'll drop the protection order and your request. That's what you want, correct? And then I set a review hearing. We'll just keep that for November the 7th. Keep that review hearing in place. Good luck to you in your counseling. I encourage that.
Thank you, Your Honor.
You're welcome.
Ohio versus Aaron Freely, case number TRC 25799.
Good morning, Your Honor.
Good morning.
Your Honor, Mr. Fraley's present. I've talked with,
Hold that for a second.
oh, sorry, Judge.
Okay, all right, go ahead.
Thank you, Your Honor. I've talked with the state of Ohio, and I believe we may have an agreement reached in this case, or a resolution.
Okay, if you want to tell me what that is.
Yes, Your Honor. He's charged with currently charged with an OVI second offense, I believe. There's been some discussion about the possibility of treatment, which he's interested in. My client has already reached out to some providers and believes that he's located a provider in Kentucky where he resides. It would be Ramey Easta for purposes of substance abuse counseling services. And so my understanding is that he would be ordered to that treatment. If he successfully completes, then that would be taken into account as part of the sentencing.
Okay. Mr. Hill.
And that is the case, Your Honor. It is a second offense high score, so that causes us to have some concern for Mr. Fraley. And we're happy that he's going to take control of this, take account of this. And if he were to plead guilty today, then we would ask the court to go ahead and sentence him in accordance with the mandatory minimums and then delay the imposition of the jail sentence and allow him to go through his treatment. And if he's successful, then we would make a recommendation about the jail time in commensurate with his completion of treatment.
Mr. Rocco?
Yes, Your Honor, that's our understanding as well.
All right, so there's a change in pleas today. I think that's the one charge we have is an OBI, correct?
Yes, Your Honor, that's my understanding.
And that plea is going to be guilty now?
Yes, Your Honor.
Mr. Fraley, do you agree with that?
Yes, sir.
You have a right to make a statement to the court if you wish to prior to sentencing. Do you have anything you want to say?
No.
Okay, so I want to make sure you understand what I'm going to do. There is a mandatory jail time on this offense, and I'm going to impose that, so I'm going to stay it while you go to treatment. And the better you do in treatment, the better I can do with the prosecutor's consent, because actually, if I don't give you the jail time and he wants to insist, he can take me to the Court of Appeals and they're going to reinstate the jail time and say you got to do it, because that's what the legislature said. So here's what we've been doing of late. Because I would rather you get clean and not have this happen anymore. Takes the risk away from you and everybody else out on the highway and your family. You know, I don't know what, I'm assuming a lot of times when people have a second offense, that means there's been some problems, and they may not just be with driving, there may be other issues. So let's get the whole thing taken care of rather than you going to jail. But I've got to be convinced that that's what you've done. If you just are going through the motions, and I don't think that you really made a change, then I'm going to give you the jail time.
Okay.
And here's the thing, you got to commit to doing everything. So I'm going to give you jail time, I'm going to hold it in abeyance, I'm going to give you community service. I'm not holding that in abeyance, you got to do that. I'm going to give you a fine, you have to do that, and you got to do your counseling. And you got to give me reports as to what you're doing in your counseling. Okay, you understand? If you don't do any, if you blow it off or don't do it or do it halfway, you're going to get the jail time.
Okay.
Okay, so it's a second offense with a high test score, so I'm going to give you a $1,500 fine. I'll suspend $500 if you're successful in treatment.
Okay.
So I want to see at least the first 1,000 paid, and then as long as you're doing treatment, we'll hold off on the last 500. Or you pay the court costs. License suspension, I'll make it 1 year. And that's effective as of the date of the offense. So April 20th for a year. I'll give him privileges to drive for work, community service, treatment, anything else he needs.
Does that cover everything you would need? Treatment, work, community
doctor.
service? Other just general medical
Medical,
appointments. Yeah.
and that'll be effective until the first review hearing, because I'm not going to extend it past the review hearing. And I want to see him in, let's make it in August. So you'll need to bring to me at the review hearings proof that you're doing your counseling. So I need a report from the agency. August the 8th will be your first review hearing.
Make sure, I think that should be fine, Your Honor. I'll confirm that on my calendar. August 8th, at what time was that, Judge?
It'll be at 9. You're not required to be here, but you're welcome to come if you want.
That's fine, I am open in the event.
August the 8th at 9 o'clock will be the first review hearing. I'm going to sentence him to 40 days in jail, 20 suspended, 2 years of level 4 probation. So So it'll be 20 days jail reporting as determined by the court. So if you show up at the first, whenever I decide, like if you show up on August 8th and you haven't done a whole lot, I could just give you the 20 days right then and say, okay, you're not living up to what you said you're going to do. Boom, you're going to jail. So you need to have a little fear. I see people all the time. Have you been to the jail? Have you been to our jail?
No.
I've visited there. I've never spent the night.
I like it. I like the food there.
Sir? Out.
Yes, sir.
You're out of order. It's not a place that you want to go. So act like you don't want to go there and take this serious and get it done.
Rather
You're
not
looking at
go.
20 days in jail if you don't. I'm supposed to give you 20 days in jail. If you talk to the Ohio legislature and say, this guy needs 20 days in jail, that's what the law says. You're asking me to do something that's not in accordance with the law. And the only reason I can do this is because he agrees with it. And the whole idea is if you got to convince me you've changed. This isn't going to happen again. If I'm not convinced of that, you're going to jail. You understand me?
Yes, sir.
This is not patty cake. This is serious business.
Your Honor, it says A, but I do not have a B case listed.
That's all there is. There's only one case. Okay, so community service, 60 hours of community service. So you're working, I take it?
Not presently.
Okay, well, then you shouldn't have a problem getting your community service done. Any day but Sunday at 7:30, you can be here to do community service.
That report here?
Yes, sir. And I want to see, when you come August 8th, I'd like to see that done then. That you've done your 60 hours. Okay, you have to meet with the probation officer today, Mr. Major in his office. Get your paperwork. Be back here August the 8th for your first hearing and show me you're serious about this. Any questions?
No.
Go see Mr. Major.
Thank you, Your Honor. We appreciate the opportunity.
Thank you.
State of Ohio versus Aaron Allen, case number CRB 25-325, A and B.
All right, this is Mr. Morford's case, that's a pre-trial.
Before you there about the mail? Where she didn't show up. Court date on Tuesday. For the safety.
Okay. What's your charge?
She had put a,
Did not do well.
yes, sir, she put
And by which just shows you there's no good, I guess. I have to set up for trial.
what is it?
I have to set up for trial. I was there working 30 days.
Suspended.
What's that mean?
It's not imposed, it's held in abeyance until... Judge, do you mind recalling this?
Case will be recalled later in the docket.
Thank you, Your Honor.
I'll come out and talk to you.
So we wait on you, is that?
Yes, please.
State of Ohio versus Tim A. Fortner, case number CRB 25301.
Mr. Morford's case set for pretrial.
That's your copy of the discovery. You will sign it.
Morning, Judge Capper.
Good morning.
Okay.
Judge, I believe that we'd like to jointly request maybe a 2-week continuance. The state has not had time to talk with the alleged victim. We would waive time too, Your Honor.
Okay, that's the 30th, June 30th.
I'm here then, Your Honor.
Okay, next hearing will be June 30th, pre-trial, 10 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Kerry Beth McCoy, case number CRB 24227.
Okay, sounds like there's still stuff we're working on.
There is, we're making progress.
Okay.
Slowly, but we're doing it.
That's good. That's what we want, is progress. Of the month, Mr. Wolford,
Yes, please, Your Honor.
July 21st.
That's good with me, I think. Yes, Your Honor, I'm here then.
July 21st will be the next hearing.
Thank you, Your Honor.
You're welcome. 10 o'clock for pre-trial.
State of Ohio versus Dustin Martin, case number CRB 24782.
Mr. Morford's case.
He was going to look into some anger management counseling? Is that right? Or not, that's been a while ago. Never mind. Okay, he was going to go to Shawnee. See what's going on there.
Did you start going to Shawnee?
Yeah, I went there back in, I think, February.
Do you have a report?
Yeah, I went there, we did therapy
Do you have a
sessions.
report?
I got something here, yeah. That was when I started.
Good. That's good. Keep it up.
Well, may I approach?
Yes.
I have records of what he's accomplished that show him in a couple pages. I think you were satisfied, Your Honor.
Okay. Okay, is this my copy, or do you want this back?
You can have that, Your Honor. If we need it, we can always get a copy of
Okay.
Bob.
All right, so we'll continue. He's been counseling, and it looks like he's starting a new phase of that. July 21st?
Yes, Your Honor.
July 21st is the next hearing.
Keep it up, I'll see you then.
Okay, when, I thought it was gonna get dropped when I showed up. What the-
That's what's working.
State of Ohio versus Troy Blaine Edwards, case number CRA 24594. Your Honor, this is set forth.
Mr. Stratus case.
Butch.
Things seem to be going good.
Edwards is at RS. Got a job, full-time job with Park and Recreation.
Yeah, like,
She's busy. Not here.
Very good.
We're getting by.
thank you. I got one.
What do you propose? I think we should keep, I'm looking back through this. I mean,
Yeah.
he's doing really well now, but it wasn't that long ago, he was not doing that great. So I think we need to keep following him for a while.
That's fine, Your Honor. Fridays or Mondays better.
But I guess that is to say you made a lot of progress since April. I looked at your screen in April, it was not that good.
I didn't look that good myself at all.
Okay. You've come a long way in a few months.
I'm good, yeah.
Gotta keep it up though.
I will.
You get complacent,
Right.
slide back. Okay.
Monday.
Maybe in July, Mr. Stratton,
Yes, Your Honor. He prefers a Monday if possible.
28th.
I have a list of my bad days here. Your Honor, that's a bad day. I'm sorry.
Oh, okay, we'll do it all. What do they have you doing at the park board?
Oh, everything, weed eating, I pick up trash, open the parks in the morning, a lot of weed eating. Fighting them cicadas, they're bad.
No, I know. I think they're about done now.
They love weed eaters.
How about August 4th?
Yeah, that's fine, Your Honor.
August 4th, and this is on the doctor's appointment here.
It is.
State of Ohio versus Aaron Mundy, case number CRA 25271.
Mr. Stratton's case and Runyon.
Please bring in your report on, Mr. Runyon.
Yes. He's getting ready to move tomorrow. Looks like you're moving to another facility.
Yes, that is tomorrow.
Okay, good job. And you still have a monitor on?
Yes.
Okay, I think, time to take it off?
Yes, sir.
Okay, I'll order it removed.
I have a client in jail that could use that, Your Honor, so.
I think we got a few in jail, both waiting for a monitor.
Take it off, you put it on somebody else.
Yeah, it's really good. Thank you.
So, is that August 4th date then?
Yeah, we can do that.
August 4th will be Mr. Runyon's next hearing. That's fine. See Mr. Major about getting the monitor removed.
Thank you.
State of Ohio versus Justin Belcher, case number CRA 25338A and B, TRC 25775.
Mr. Steyer's case.
Your Honor, I believe the state is interested in making an offer to reduce the charge from OVI to physical control on the basis that Mr. Belcher was allegedly found passed out in a vehicle. We would join in that recommendation, or in that motion, so if the state, if this court grants it, we would enter a guilty plea to that. The felony matters, he's being considered for the QRT program, but a decision has not been made on that, so we would still need to come back another time, at least once for that issue, and then obviously I don't know if the state, if the court would want to come back for sentencing anyway on the other matter.
Okay. It's amended to physical control.
And I don't have the section number for that off the top of my head, I apologize.
11-19-4. Yeah.
And the basis for that, Your Honor, was that he actually was found to have been passed out or something in the parking lot at the gas station for over an hour before any law enforcement encountered him. So we really feel that this is more of a physical control issue than an actual OVI.
Okay, this just happened, so there wouldn't be any urine test results back at this point.
No, test results are not, I mean, I assume they're not anyway.
No, we don't have the results back.
Okay, on this one, I'm going to accept your plea. You agree you're pleading guilty to the OVI, or physical control, getting in physical control of the
Yes, sir.
vehicle while impaired. I'm going to delay sentencing, and when do you think the PRT would, they're going to do an assessment of him?
Yeah, it'd be fairly quick, but I'm not back here until, for the next couple court dates.
When are you coming back?
I will be back the 27th of June. And then I'm also still not here again right now until until the 14th of July. I've got a bunch of jury trials and set here lined up in a row.
Let's do July 14th, because that 27th is really packed. So that gives us some more time to figure this out. Okay, July 14th, I'll set it for sentencing. Mandatory hearing. Continue with your counseling and
State of Ohio, Kelly Doss.
Thank you.
Case number CRA 25206, CRB 25207, A and B.
Mr. Steyer's case. Preliminary hearing. Okay. Mr. Doss just started inpatient treatment with RRS, and so far so good.
Your Honor, Mr. Doss would also like to address the question of his ankle monitor and request that that be removed. He's going to, I guess, getting to where he's going to begin having the ability to get passes, and he's afraid the ankle monitor might interfere with that.
It has already.
It has already, he says.
Well, he just started though.
Recognize that, Your Honor.
So not at this point. Down the road, yes, but
Okay.
no, not yet.
So, I'm not sure what kind of a time frame we're looking at, but again, my next availability past the 27th is going to be the 14th.
Okay, that'll be it then, July 14th.
Thank you.
State of Ohio versus Holly M. Lewis, case number TRC 25-956, A, B, and C.
Mr. Steyer's case, 1 year hearing, 3 trial.
Your Honor, Miss Lewis continues to have some issues with her medical card. She was until recently, I guess, a New Jersey resident. She will have Ohio insurance as of the 1st of July. So at this point, we would like to ask to postpone this matter a little bit further to give her time to get her insurance active so that she can get onto a treatment program.
Your Honor, I believe that she had family reach out to us and we were working to get her in to get her as
Okay. The basket?
You were able to
She's willing to work with, as far as like the self-pay or whatever, but the concern is might possibly not be able to afford that.
The issue,
Or if they can take Ohio after.
the issue is whether self-pay would be an issue. If she starts on self-pay, would that still be able to transition into?
It's self-pay, but we're not going to take anybody's food. So it's just, we have to do it for a procedure. She'd still be able to attend services and once the medication kicks in, we'll be able to take care of it.
So that doesn't kick her off being able to use Medicaid?
But, I'm not getting Ohio Medicaid.
well-
It'll be private, so
Oh, it's going to be private insurance she's getting, not Medicaid?
Ohio Medicaid denied me.
Okay, she's been denied for Medicaid, so she's going to be getting private insurance.
Do you have, is it then?
Who's it going to be through?
So I have to shop, I tried through work, but that's too expensive, so I'm shopping on
You're
Marketplace
basically just doing
now.
Marketplace.
I'm figuring out Marketplace now, but Jersey doesn't end until 6:30, so Ohio can't pick up until 7/1.
Okay, when you said New Jersey and Ohio, I assumed that you meant
Yeah.
Medicaid. I apologize, I misunderstood that.
It is Jersey Medicaid, but no one will take
Well, right, and
Jersey.
then that's going to fall off on the 30th, and you'll be
then
able to.
Ohio will pick up.
I feel like OVP is about our only provider that I know takes private insurance. I know they don't take I understand they won't take Jersey, but
sorry.
we're not talking about that. We're talking about once you get insurance.
Yeah.
At any rate, we're going to need to continue this. I'm going to ask to come back, I guess the 14th looks like the date we're using for my cases. But I think we would probably be better off having a plan than just coming back without a plan in place.
Is Ms. DeMint still here?
She was here, I don't know if she's here still or not.
Yeah, I'd like for her to talk to her about getting in. I don't want to wait for the 14th.
Right, I think we need to have a plan of some kind, Your Honor.
All right, Mr. Mayor, can you talk to Ms. Lewis about, she's going to be transitioning to medical insurance, and I think maybe ODP would be the best option for her.
Okay.
July 14th will be the next hearing for preliminary hearing.
Oh, no, I got you. That's all right.
Thank you.
Thank you.
State of Ohio versus James DeMint, case number CRA 24-290, CRB 24-635, CRA 24-786.
Smith's case.
It is, Judge, it's actually Tyler's case. He's in North Carolina. Mr. Mint was put in treatment last week. I think it's just a follow-up to make sure he's 2 weeks. He's doing what he's supposed to be doing, so I would stand up for him.
That's a good report from hometown recovery.
Yes, he's doing well so far.
Okay. Anything else, Mr. Bennett?
Well, I'll just let you know that Buford heparin shot, I'm no longer going to take it, but I'm still positive for it. I've been, so it's kind of,
You're not going to do any kind of MAT?
no, sir.
Okay. All right, we'll continue to monitor you.
Judge, anticipating this will go up 30 days. Tyler shooting 18th or 21st of July.
July 18th.
I'll tell him. Thank you.
July 18th will be Mr. Dement's next hearing.
Thank you.
So, 9 a.m.
10.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
Your Honor, we're ready to go to the lunch county.
Okay, we have a lot of hearings to do from the jail, so we're going to go here now.
State of Ohio versus Stanley Bennett, case number CRA 25-342, CRB 25-343, CRB 25-1319, CRB 23-163. 6 Bentley is on deck.
All right, on Stanley Bennett, Mr. Steyer is the attorney of record. And Mr. Steyer,
Easier.
I think we're waiting for a GPS monitor.
I believe we were. Obviously, one has been freed up, but I don't know where in the rotation he was.
I think we've had a couple. Yeah, he was. Freed up. We need Mr. Major to come in now. One was freed up on Friday. And at least one, maybe two today. Just wondering, Mr. Bennett was one of the persons waiting on a GPS monitor to go to treatment. I know I think we've got 3 weeks freed up since Friday. So
Yeah.
I wonder where we are.
I'd say he's probably on the list. I don't know exactly who's next on the list, but I'm sure we've got some coming off, so he should be this week.
Sure. Sorry.
I'm not here again till, well, the 27th, but you said you didn't want to add on to that, but I think in this situation, we might want to.
Let's make sure, this Friday, what's your situation?
I'm going to be on vacation.
Okay. Well, I'd like to add it to the doc just to make sure he's not sitting in jail.
Is there anyone who knows they're going to be here Friday?
That's fine.
Yes. Mr. Smith could cover for me?
I'll do that, Judge. Sure.
We'll put it on the docket for Friday. You should have a monitor before then, but I don't want him sitting in jail without one, so.
Right.
Put it on the docket for June 20th, because there should be a monitor available now. He's gonna go to Southern Hope, and we'll let Mr. Quan know he should be available here shortly for pickup.
Perfect. Thank you, Your Honor.
June 20th is the next year.
State of Ohio versus 6 Lee Sue Bentley, case number CRA 25-359, CRB 25-360, and Connie Burnside is on deck.
Six Bentley should be the next person. Ma'am, are you 6 Bentley?
Yes, sir.
Ms. Bentley, my name's Donald Capper. I'm the judge of the Lawrence County Municipal Court. That's where your cases are filed. You're appearing in the court today on a monitor, and Your image and what you say is being recorded, so you have a right to remain silent. You don't have to say anything. If you choose to make statements, though, because it's being recorded, it could be used against you later if you denied something that you've already admitted. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state of Ohio prove these charges beyond a reasonable doubt. Do you understand those things?
Yeah.
You got two charges that I'm going to go over with you. The first is possession of a fentanyl-related compound, and the other charge is theft. The 359 is the case number on the possession charge, and it alleges on June the 14th in Fayette Township, you knowingly possessed or used a controlled substance with fentanyl in the compound. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. You understand that charge?
Yeah.
The next charge is theft, and that's case number 360. It alleges June the 14th you tried to deprive Walmart of property without their consent, and that was in Fayette Township also. Maximum penalty for that, 6 months in jail, $1,000 fine. You understand that charge?
Yeah.
So you've got two charges. One's a felony, one's a misdemeanor. You have the money to hire a lawyer to represent you. Do you have any money to hire a lawyer with?
No.
Do you have a job?
No.
I'm going to appoint your fellow Scioto County in Stratton.
Your Honor, I have a conflict on this case.
Okay. I'm not going to appoint him then. I'll appoint Mr. Smith to represent you. So Mr. Smith is here in the courtroom. You can see him if you look at the screen there. He's going to be representing you. And I've got a New Boston, Ohio address. Is that correct? Is that your correct address? You live in New Boston now?
Portsmouth.
Okay. What's the state's position on bond for Ms. Bentley?
We would not oppose an OR bond if Ms. Bentley was agreeable to seeking an assessment and treatment for substance abuse.
Judge, I know Bethesda has a bed available if that's an option. I don't know her pay source, but
Do you have a medical card, Ms. Bentley?
I'm sorry?
Do you have an Ohio medical card?
I don't know what you're saying.
Do you have Medicaid, an Ohio medical card?
No, not currently at all.
Have you had it in the past? Have you had a medical card before?
Yes, I did before.
And it just expired, you didn't renew it?
Yeah.
Okay. Have you been to treatment before?
Yeah, but,
Where'd you go to treatment before?
at Portsmouth,
Counseling center?
no, Hopes Words, a couple years ago.
Okay. Do you have kids?
Yeah.
Where are they?
They're with their dad.
Okay, well, Bethesda is willing to take you as an inpatient treatment. Are you willing to go? Bethesda also, let me tell you, this is a faith-based program.
What's my other option?
Go to the grand jury and get indicted and take the risk of going to STAR or prison.
Yeah, I remember the treatment.
I can get her today.
Okay. I'm going to let you go without a GPS monitor because you have a felony, so there's no place you can go to. A felony warrant, if you decide you're going to run, that warrant will be issued and it'll be good anywhere in the United States and most other countries. So there's no place you can go hide. You understand?
Right.
So it's best to get clean. Do you want to get clean? Is that a yes?
Yeah.
Okay. Well, we'll try it. Does the state willing to leave it here?
For the time being, what I hear so far, I don't know whether this young lady really understands this completely, what she's facing at this point.
Yeah, you have a felony, so without
It's
getting...
my first felony.
Well, but it's a felony, so, you know, what a felony means is when you get charged with a felony, it's considered so serious, you have to be indicted. You probably heard that word, indicted. That means your fellow citizens, a group of them meet together, hear the evidence, and decide, yeah, this person needs to be prosecuted. So that's serious business, because a felony, you can go to prison over. Misdemeanors, you can only go to the county jail. So you have one of each. You got a misdemeanor and you got a felony. So from what I understand, I'm reading between the lines, I think the state was mostly interested in you getting clean. If you do that, you could probably get the felony dismissed. So you don't have it on your record, you don't go to prison, you get clean. I mean, it's a win-win all the way around. But you're going to have to do your part. You're going to have to participate in counseling, do what you're supposed to do, get clean. Is that what you want to do, or are you going to say, hey, I just want out of jail and I want to keep doing what I've been doing?
I want to get clean.
I don't know if she's ready.
Maybe we leave her in a couple days?
Let's come back on Friday.
I'm here Friday.
Okay, I think you're still under the influence. I've had,
No, I was just listening to the officer behind me, I'm sorry.
okay, well, I'm going to let your lawyer call and talk to you, because right now I'm not impressed that you're really serious about getting
I'm
treatment.
serious.
Okay, listen up, don't interrupt me. Because I've had this happen before. I've had people that are still under the influence, and I'll let them go to treatment. They go in the front door and out the back door, but they're not really serious yet. So you need to understand how serious the circumstances are. So let your lawyer call down and talk to you, and then we'll try this again later in the docket. Mr. Smith.
State of Ohio versus Connie Burnside, case number CRA 25358, and Tara Kerr is on deck.
All right, are you Mr. Burnside?
Yes, sir.
Is it Connie, is that how you, or Canny? How do you pronounce your first name?
Yeah.
Nine, all right. All right, Mr. Burnside, I'm Judge Capper. This is your, what's called arraignment hearing, the purpose of which is to tell you the charges and then go from there. So let's do that first. Before I tell you the charges, let me explain your rights to you. You have a right to remain silent. You don't have to say anything. But if you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. You understand those rights?
Yes, sir.
You're charged with disrupting public services. The state's alleging that on June the 14th, 2025, in Fayette Township, you purposely, knowingly damaged or interrupted television, radio, telephone, other mass communication. Usually it means you interfered with somebody's phone, that's what they're saying. You took somebody's phone. That's a felony of the 4th degree. The maximum penalty is 18 months in jail and a $5,000 fine. Do you understand the charge?
Yes, sir.
Do you have the money to hire a lawyer?
Sir?
Do you have money with which to hire a lawyer?
No, sir. Can I get a lawyer, please?
That's what I'm going to determine. Do you have a job?
No, sir.
You have no income right now?
No, sir.
All right, Mr. Stratton?
Yes, Your Honor.
I'm appointing Mr. Stratton to represent you. He's in the courtroom. He's heard your arraignment. What's the state's position on bond for Mr. Burnside? And I have an Ironton address for you, sir. Is that right?
That's, well, I've been trying to get it changed.
What is your correct address?
128 Harvard Drive, 717.
Ironton?
Kisdale, Ohio.
State's position on bond?
State's not opposed to no harm bond, Your Honor.
Okay, sir, I'm going to let you out on your own signature.
Can I say something before you let me go?
Well, your lawyer's probably going to say.
No,
he doesn't want you to.
no. I would suggest you not. Not right now.
Here's the thing, it can't help you, but it could hurt you.
That's
So
right.
There's no benefit.
I just was trying to say I'm trying to get my baby. I'm trying to go to ARC to get my anger management. I'm going to go get medicated, and she's currently pregnant, and I'm trying to become a better man, so me and her can move forward. That's all I'm really trying to say. I'm not doing something crazy.
All right, all right, you said it, good. Can I get a phone number, Your Honor?
Do you have a phone number where Mr. Stratton can reach you?
I don't have the phone number. 740-237-2221 is a number that my girlfriend has, and she, like, always talk to her.
What's her name?
My mom.
Oh, good.
She's here in the court.
Please.
Can you come up here, I'll come to you.
She's here today, so she can talk to you. She can talk to
Here, come up
Mr.
here.
Stratton if she wants to. She doesn't have to.
Yeah, sounds like it won't be a problem.
I just want to do the right thing and get my anger management, because I know my anger to be a problem. I just want to go get medicated and.
Yeah,
Target county nervous in public setting, but no, he did not physically harm me. I think his best interest would be to go to anger management, get medication. Has no violent history. He just has anger that he needs to.
I think we'll take care of that by next time, Your Honor.
Okay, so we're going to pick a date when we're going to come back, and do you want to waive the 15 days?
Yeah, I'll wait those days, Your Honor.
Okay. Do you have a preference as to the date? And I know there's some days in July you're not available.
Yeah, the 7th and the 21st and 28th, but any other day.
How about the 11th?
Yeah, we can do the 11th.
Okay. Mr. Burnside, I'm setting your next hearing for July the 11th.
Yes, sir.
Preliminary hearing. Excuse
Bless
me.
you.
So I think what you suggested you're going to do is a good plan.
Yes.
And discuss that with Mr. Stratton, and he's going to talk to, I'm assuming this is the significant other that seems interested in you getting counseling also. So you're okay with him talking with her? You're okay with him talking to her, Mr. Burnside?
Yes, sir. I'm going to call that.
All right, July 11th is the next hearing at 10 o'clock.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Tara Curd for Lawrence County Jail, case number CRE 25332, and Michael Davis is on deck.
Another person that was waiting on a GPS monitor, and she's going to go to Bethesda.
Yes, Judge. I'm hoping one of those three that opened this morning are available to her.
The last I checked, she was like number 2 on the list.
She should get one. Let's just put it on the docket for Friday to make sure.
Yes, sir.
She did get one. But it should happen today. Order her release to Bethesda with ankle monitor.
Thank you, Your Honor.
You're welcome. Preliminary hearing for Friday, June 20th.
State of Ohio versus Michael Davis, case number CRB 45362, A and B, CRB 24215, CRB 24767, CRB 24649, A and B. Your Honor, there's new charges.
All Okay.
I was aware, I was told there were new charges, I don't know what they are, if I could approach and take a quick look.
One of them says, "Well, I'm gonna protect her," and it was already
It'd be
gone.
better if you didn't talk, just let me do the talking, please.
Here's the A case. Here's the B case.
Is there a C case, Your Honor? Okay. We would waive reading of those and I'll put him not guilty. There's not a charge related to the protective order, Mr. Davis. There's a mention of it in one of the statements, but there's no charge related to that. You may recall, Your Honor, that about a month ago, roughly, the alleged victim of this charge came in and asked to have a protective order against Mr. Davis dropped. That's been done. I think that's the protective order they referred to in the paperwork. It's not active. I don't think a charge has been filed related to it. So that part's been, it looks like it was dealt with before it even got into the courtroom, Mr. Davis.
This appears to be new factual.
Well, there's mention of the protective order in one of the narratives, but there's not a charge for that. So,
What's the state's position on bond for Mr. Davis?
Lived in that house and always.
sir, it would really be better if you didn't speak. You're not going to help yourself, I promise you.
Your Honor, we asked for $5,000 cash or surety bond.
I think that's appropriate under the circumstances. I'm going to set the bond at $5,000 cash or surety with a protection order to stay away from Lindsay McMillan.
Do you have somewhere else you could go if you were able to bond? Do you have somewhere else you could go if you were able to bond out, sir?
I don't know, I mean, why can somebody lie on me like that?
It is the system we have, sir. Were you to how this works, if an accusation is made, charges are filed, we can deal with them as we go, but at the moment, do you have somewhere else you could go if you bonded out?
Yeah, is there any way I get another one with a table monitor or anything like that?
Your Honor, it sounds like there may be a substance abuse issue here that might be dealt with through an ankle monitoring treatment. So I'm going to raise the question of an ankle monitor treatment and an OR bond. However, I'm going to tell Mr. Davis that even if the court grants that, there is a waiting list. I don't know how quickly you'd be on it, and I'm not available again until the 27th, I believe, is the next day.
Yeah, I just got my job back, and I just got my job back, a good job. And I don't want to do the inpatient treatment, I already do outpatient.
Well,
Bond is set at $5,000 cash or surety. The allegations are pretty serious, so.
I would ask to go ahead and set this back for the 27th. I realize the court wouldn't want to set much more that day, but I feel like this probably needs to be back, we need to be back in on this one as quickly as we can. I don't think it's possible. Is there an amount you believe you could post, sir?
I mean, a lot of those, you might be able to post, a couple $100 for a bond.
I would ask for a $2,500 cash surety bond, Your Honor. I think that still gives us the safety of a cash surety bond, but also maybe something you can post.
Then how much would that be to get out, about 250?
That's in that neighborhood, sir.
Mr. Hill, your response.
Well, hold on, won't get you out, I don't know.
Well, I think that the bond that the court has set already is appropriate. And was there some other question about?
Where has he been working?
Where were you working, sir?
So I work for CNA Tree Service.
Tree service, Your Honor.
Who's
I was mowing grass and now,
Hold on, he wants to ask you a question, sir.
who's your supervisor?
Ann?
Yeah,
Last name?
Clay.
Do you have a phone number?
Do you know their phone number?
What, trying to blind me out?
Do you know their phone number, sir?
Of your employer supervisor?
Yeah, Fannie Clay.
Phone number?
You can try to call, 304 416 9898. I just got my job back,
At this point, I'm leaving it at 5,000. I may have probation call, and if we confirm he is working, active, and get a good report, I may consider lowering it. But this time it's going to stay at 5,000.
I'm going to ask that the other matters also be set for the,
Yeah, I'll put everything on for June 27th.
so what is he gonna, I mean, I've been working every day.
we're going to try to call, sir.
To bond me out or what?
We're going to try to call, sir. That's all I can answer right now. Let's see what I can do. Your Honor, may I?
Yes. Yeah, it's on the phone.
Thank you.
State of Ohio versus Danielle Ham, case number CRB 25-298, A, B, C, and D, and Christopher Kipp is on deck.
And Danielle Ham is still in jail. She's represented by Mr. Walker. She was going to go to the counseling center with a monitor. But she's also waiting on a monitor.
Yes, Your Honor.
We have some available.
I believe she's last on the list, so I don't know if that's going to include her or not.
I'll order her released to the counseling center with a monitor, and I'm going to put her on the docket for Friday just to make sure that happens. June 20th, 10 o'clock is the next hearing.
Okay, so did you say they do something on your own?
They have some that have been released. We've had several people waiting, so I don't know exactly where you are in the pecking order.
She's last.
Okay, so I've been told you were the last one to get one, so we'll see. I don't know if it'll happen today or not. I suggest to the county they buy some more.
Okay, so you're,
Say, I would suggest to the county they might buy some more rather than pay, what is it? It's at least $60 a day to keep somebody in jail.
yeah.
But I don't need to make those decisions.
Thank you, Judge.
You're right.
Thank you, Your Honor.
State of Ohio,
Friday.
State of Ohio versus Christopher N. Kipp, case number CRB 25357, and Amber Mills is on deck.
Okay, this is an arraignment for Christopher Kipp. Sir, you're Christopher Kipp?
Yes, sir.
I'm Judge Capper at the Municipal Court, Lawrence County Municipal Court in Chesapeake. This is where your hearing is being held. You're being on a monitor, recorded on a monitor here and showing up in the courtroom on a monitor, so everything you say is being recorded. You don't have to say anything. You have the right to remain silent. If you do make statements, they can be used against you later because it's being recorded. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state where I approve this charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
The charge against you is domestic violence. The state's alleging that on June the 13th in Fayette Township, you knowingly caused or tried to cause physical harm to Jenny Lynn Ferris, and that Ms. Ferris is either a member of your family or lives in your household with you. domestic violence carries a maximum penalty of 6 months in jail and a $1,000 fine. That's the most you can receive if you're found guilty. Do you understand the charge filed against you?
Yes, sir.
And you already said you understand your rights. How do you plead to the charge?
I'm pleading, not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
No, sir.
You have no income?
No, not currently, no.
Mr. Morford, I'll appoint you to represent Mr. Kip. Entering a not guilty plea for you. What's the state's position on bond for Mr. Kidd?
We'd want to make sure that Mr. Kip, if he gets out of jail, that he goes nowhere around his mother, who he's alleged to have been slapping around.
Oh, this is Jenny
It's his
Ferris,
mom.
this is his mother? Okay.
So,
Thank you, sir. You mind if I speak?
we'd ask for a $2,500 cash or surety bond and a protection order.
Well, your lawyer is here, so he could probably advise you. The smart thing, I think, to do is wait and talk to him, because what you tell him is privilege. It can't be used against you. What you blurt out here in the courtroom is free game. If you say something the prosecutor likes that he wants to use against you, he can play it back.
I'm well aware of that, sir.
Then
But it's okay, I can wait and speak to my lawyer, though.
Okay.
I'll give you a call here in a minute and listen to Judge Capper without interrupting.
Do you have a place you can go live other than with your mother?
Yes, sir.
Where would that be?
I have my grandma's, I have my aunt, I have my fiance's, I have several places.
Okay, so I'm going to release you on a signature bond. What that means is I'm letting you guarantee your own appearance. So you're going to sign a piece of paper that says, if I don't show up, I have to pay $1,500 for not showing up. Plus, you get a warrant when you don't show up. So if you want to not go back to jail, the best thing to do is show up as you're ordered to for your hearings. And I'm also warning you stay away from your mom. So you don't go around her, don't contact her, don't post anything about her. Do you agree with that?
Yes, sir. Is there any way she's allowed to drop that?
She can talk to the prosecutor at any time she wants to.
Okay. All right.
Okay, so I'm letting you out on a $1,500 signature bond, and then we're going to talk about when to come back for your next hearing. What's your availability, Mr. Morford? Let me give you some dates. The 30th of June is okay. That's 2 weeks from today.
I'm here then, Judge.
Okay, so Mr. Kip, I'm setting your next hearing for June 30th. It'll be a pretrial at 10 a.m. And it's at the court in Chesapeake. Do you know where the court is located?
Yes, sir. Right across the flea market.
Correct, that's our claim to fame. We're across the street from the flea market. So you gotta be here then, June 30th. Do you have a phone number where your lawyer can reach you?
Yes, it's going to be 606-371-0847.
Thank you, Judge.
Okay, obey the protection order. This means don't go around or contact your mom. Be back here June 30th in the court in Chesapeake for your next hearing at 10 o'clock.
All right, thank you.
You're welcome.
Thank you, Your Honor.
State of Ohio versus Amber Mills, case number CRB 23-621, CRB 23-556. Carlos Quinones is on deck.
Your Honor, this is Mr. Stratt's case for pretrial.
Yeah, Your Honor, we're waiting on the monitor. Just bring your trunk outside. We have no monitor. I hopefully we'll have some today, so.
Well, we have freed up some today, but we got a bunch of people that need monitors too, so I don't know where she is in pecking order.
We could
June
just-
20th, we'll set it for another hearing, hopefully we should get one before then.
All right.
That she can be released to hometown with a monitor.
Your Honor, I believe that is a sentencing, by the way.
Okay, the sentencing.
All right, we'll see you Friday.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Carlos Quinones, case number CRB 25361, and 6 Bentley Hyundai.
This is for arraignment, Carlos Menendez. All right, so, sir, are you Carlos Quinones? And then I've got Conte also. Which is your last name?
My name is Carlos Quiñones. No hablo inglés, no sé si puedan poner un traductor.
All right, well, we'll have to get a translator. I took Spanish for 2 years from Mr. Remero about 50 years ago. So, no hablo español for me, un poco. If you think you can't understand what I'm telling you, we'll have to wait till we get a translator. Is that what you want to do, sir? Okay. All right, we'll have him back once we get a translator.
Okay.
All right, we'll see you later. I'll get a translator on the phone. It may take a while.
State of Ohio versus 6 Bentley, case number CRA 25359, CRB 25360.
All right, then this is Mr. Smith's case. You got a chance to talk?
I did, Judge. She said she woke up late. I was able to have a coherent conversation with her. I inquired of Taylor, I don't know how long drugs stay in your system. It's an allegation of fentanyl-related compound 2 days ago. Should not still be in her system. Unless she took a truckload of it, then she'd probably be dead.
Yeah.
So I had a good conversation with her, Judge.
Think she's ready? What do you think, Taylor?
I have some reservations. I think she might run. I'm going to be
I was
honest.
going to say, we had the monitor situation again.
But, yeah.
That would not be a deal killer, Judge. If she has to wear a monitor, she will wear it.
Well, we don't have any.
Yeah, I was going to say, this might be at June 20th.
We have so many people that need
So
monitors.
that won't be a problem. I'll stick her out as far in the country as I can. It'll take her a while to get to town. Maybe I'll catch her before then.
Okay. Well, and your case isn't going to go away if you run. You know, it's only, and the other thing that could happen then is that you get a worse outcome for yourself legally. I mean, you're facing a felony. I know this is kind of complicated. You're facing a felony, which means eventually it will go to the common police court. You're in the municipal court now. They're agreeing to let you go to treatment and just stay here. You're not going to get indicted. You're not going to go to common police. But if you mess up and say run from this case, then they can say, okay, we're going to indict you and take you to common police court, and then you're facing prison time.
Right.
So if you want to get clean and not have a felony on your record, the best thing you can possibly do is go to treatment and do well. Everybody just wants you to get clean. But you know what? It doesn't matter what we want. It matters what you want. If you don't want to get clean, it ain't happening. If you want to get clean, this is a great opportunity. What you're going to get, if you had to pay for it out of your pocket, it would cost you thousands upon thousands of dollars. But it's like throwing money in the river if you don't want to get clean.
All right, I'm ready to be clean.
Okay, you said you got kids, right?
Right.
How old are your kids?
I got 5 of them. 3 are in Texas.
You got 5 kids?
Yes.
How old are they? What's the age range?
14, 13, and 10, 8, and 6.
Do you ever see them?
Yes, all the time.
Okay.
We'll continue that once we get her stable.
Okay, so they say they're going to encourage that relationship. And I'm assuming you want to continue that relationship.
Yes, I do. I actually do.
Okay. And you want the best possible life for them, right?
Right.
You don't want them to be addicted. Right? You don't want them involved in the drug culture.
Right.
Well, I don't think this is rocket science, but let me just say this. You getting clean is the most important and best thing you can do for your kids if you don't want them involved in drugs. We know statistically, people that use drugs, their kids are more likely to use drugs. Do you want your kids to have a good life and not be involved with drugs? You gotta get clean. Do it for them. If you're not gonna do it for yourself, do it for your kids. We're gonna give you a chance. Show me you wanna do that. I'll order her release to Bethesda without an ankle monitor on a $2,000 signature bond. And then, how about 30th? Are you here the 30th?
Judge, I'm not here, I'm here, I know the 27th is a bad day, and I'm not back till the 7th of July.
July 7th.
Okay.
Taylor will let me know if you run. I'm going to issue a warrant for you immediately.
Okay, that's fine. Thank you, Your Honor.
July 7th is your next hearing, 10 o'clock.
At this point, as far as I know, the only case we have to recall is the jail is the one
Where we need to translate.
the translate.
Thank you, Your Honor.
Thank you. Are you ready to call Aaron now? Do that.
Aaron Allen.
State of Ohio recalls Aaron Allen, case number CRB 25-325, A and B.
It's your Morford's case set for pretrial.
Your Honor, we're going to have to ask you to set this for a bench trial.
Okay? It looks like the first date I would have that would be good for this, the 30th, 2 weeks from today.
That's fine with us, Judge. If you want to go further out, we waive time.
What's the state's
He-
position?
We're okay with that date, Your Honor, as far as we know. I mean, it's going to depend upon witnesses' availability and things of that nature.
Well, just file a motion if they're not available. June 30th at noon for a trial.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Zachary T. King, case number CRA 25-363, CRB 25-364.
Sir, are you Zachary King?
Yes, sir.
And I've explained the rights of defendants several times today. Have you been here for any of those?
Yes, sir.
You want me to go over it again with you, or do you understand your rights?
I understand.
Case number 363 alleges that on June 14th of this year in Union Township, you not only caused or created a substantial risk of serious physical harm to Milan Kaner, and either a member of your family or household by means of strangulation or suffocation. That's a felony of the 3rd degree. The maximum penalty for that is a $5,000 fine and, I'm sorry, $10,000 fine and 5 years incarcerated. Case number 364 is a domestic violence charge. It will have the same time and place and person as the complaining party victim, and that person is either a member of your family or household that you caused or tried to cause physical harm to that person. That's a domestic violence charge, maximum penalty, 6 months in jail, $1,000 fine. Do you understand these charges, sir?
Yes, sir.
Do you have the money to hire a lawyer?
Yes, sir.
Have you hired a lawyer?
I have not yet, sir.
Well, this one charge, the felony, you have a right to have a hearing within 15 days on felonies for what's called a preliminary hearing, just a probable cause hearing to make sure there's enough evidence for the state to go forward. So I can set it within 15 days. If you think you can get a lawyer in that time frame, if you want more time, I can give you more time. Do you want more time, or you want to keep it within the 15 days?
Maybe just a little more. I have some money I can put down for a lawyer. I'll probably just have to make a couple payments.
Okay, so when would you like beyond the 15 days? How much time are you thinking you need?
Maybe just an additional week or two.
Okay. How about the 18th of July?
Yes, sir.
That's good for you?
Yes, sir.
That's a Friday, July the 18th, actually the month. Now, July 18th will be your next hearing, 10 o'clock. I'm sure the state, are you going to ask for a protection order on this?
We are, and I've already also prepared a time waiver to also.
Okay, so you're going to sign a piece of paper that just says, I'm agreeing to go beyond the 15 days for my hearing. And I'm going to order to not go around Milan Kaner. And that means you can't go around her, you can't contact her, you can't text her, you can't post things about her. Do you understand that?
Yes, sir.
And you have another place to live other than her?
Yes, sir.
Okay. Your bond is continued that you posted? And I'm putting down that you will hire counsel. Do you have any questions, Mr. King?
I do. My children live in the home with her, and I'm staying at my parents in Kentucky now. I didn't know how that would work, where...
Well, I'm ordering you stay away from her. I'm not ordering you stay away from the kids. If there's a third party that she will agree to cooperate to facilitate visitation, then that will work. But I don't want you to get, the main thing is I don't want there to be an allegation of another incident and somebody get hurt. So neutral third parties that you both can agree on, that's fine. Don't take things in your own hand. If you think it's going to be a problem, I can set a hearing earlier to come back and address it.
I don't think it will be, we have mutual third party.
Okay. All right, as of now, July 18th is your next hearing. If you hire a lawyer and they say, I can't be there the 18th, they may tell you a different date to come in, but otherwise, be here on the 18th at 10 a.m.
Yes, sir. Thank you.
And don't leave, I'll give you a copy of this. I'll give you a copy of this, so just hang out.
State of Ohio recalls Michael Tilley, case number CRB 24437. Michael Tilley.
Your Honor, he is out in the hallway, because I think you...
Yeah, I banished him to the hallway. Come back in now.
I'm sorry.
I apologize, sir. Apology accepted. Okay, so are you at PATH now? Or
Yes, sir.
Okay.
Yeah, may I approach now?
Yes.
Your Honor, it was like 4 feet to get this, and I still don't think it's satisfactory.
It's not much, but it does say he's been there, so.
Yeah, it's, and he has showed me messages where they told him they've already sent it, they didn't send it, And then we've been trying.
Yeah, I've been on the phone with them in the office, my wife trying to get a hold of them and everything.
Yeah, so,
Let me see if I still have access to that. I had a contact person.
I'm shy, man.
And this report, which I didn't show you, but it only lists the dates that you've been there.
Yeah, it doesn't give you nothing.
Doesn't even say anything else.
I keep telling her to put like stuff in there, man. She don't want to listen.
Yeah, I do have, let me send a message myself to my contact. Last time I texted with him was in March, so I don't even know for sure that he's still there, but he was there and was pretty responsive. And I'll copy you on what I've sent.
All right. Yeah, it doesn't say anything. It says you're running and like 5 dates. When's your next day?
It should be either next week or the week after.
Okay. You haven't missed any, have you?
No.
Okay, good.
I've been walking to them to make sure I get there.
Okay, good. How far am I walking? Is that?
Well, it's not very far. I live in Jackson, so
okay.
it's like right there.
Okay, good.
Okay, so I copied you and Mr. Hill on what I just took a picture of what they sent it to the person that I know passed and asked to get a more detailed report. So we can hopefully maybe have that next time.
Yes, Your Honor.
I'll make sure to tell her to put more details in.
Yeah.
I'm sorry.
That's,
And what's your dates in July?
the 3rd, 7th, 21st, and 28th are bad days. Which are like.
Okay, so the 18th, okay?
Yeah, the 18th is fine.
Let's do July 18th.
The 18th.
Okay, July 18th.
Yes, sir. I appreciate you, sir. I do apologize again.
Thank you.
Yes, sir.
State of Ohio versus Dillon and Sloan, case number CRB 24676. Your Honor, is set for sentencing.
Yeah. How much do you pay? Have all of it. Oh, you have all of it? Fantastic. Very good, Frank. He has all of it. Do we?
Good.
Okay.
Okay. Supposed to do sentencing today on this, right?
Well, Your Honor, he was supposed to pay the restitution amount and cost, and then it will be dismissed. He has it all today to pay.
Mr. Hill.
And that is what we agreed to, Your Honor. And we're real happy that he came up with, if it was $999, and then he needed to pay costs.
Correct.
So if that's the case, then if he's brought it today, then we agree to dismissal.
So I know how the court usually just set it for another date, and he goes out and pays, and then that date will be vacated at some point in the future.
So you have, let's get this up. It's 24676. And shows what the costs are.
Sure. 1250.
Okay. Here's a sheriff fee, $10.
Enough.
I know. Okay.
It's 160, the
He's paid the $1,000 restitution. Is that correct?
$999.
Okay.
He says he's going to pay.
Let's see, it's $125, $25, $49.64.
4964, is that sheriff's fees?
The sheriff fees, there
$49.64.
were multiple sheriff fees.
Okay.
And then 25, 125,
25 plus 25 plus 49.64 equals $1,198.64.
Okay, the balance is showing $1,208.28.
Yeah, Your Honor, I think you added that incorrectly.
1208.28, so that's $10 more. Oh, yeah, there was another $10. You must, on that 49.64 must not have, because I saw on there was a $10 sheriff fee too. So it's actually 1208.28.
1208.28, he'll pay that.
That's everything, and he's got all that today.
He's got all that today.
Okay, just to ensure, I'll set it for another hearing, July the 18th, and if it'll be dismissed if he pays the 1208.
Go pay it today, and you won't have to appear.
Okay, so. Yeah.
Thanks, sir.
Go see the clerk.
Thank you, Your Honor.
You are.
State of Ohio recalls Carlos Quinones to Lawrence County Jail, case number CRB 253621.
Okay, so we got Mr. Quinones back for arraignment, and we have an interpreter assigned by the Ohio Supreme Court. Is that correct? Is there an interpreter there? All right, I don't know if this is going to work. All right, you're going to have to speak up because the person that we're doing this hearing with is on he's appearing by teleconference, so he's not in the courtroom with me.
Okay, then we'll speak up.
All right, would you identify yourself, the interpreter, and tell us what your name is?
Yes, the interpreter's name is Tanya, ID 366635, the will translate that. Hola, soy su intérprete, mi nombre es Tanya. You may proceed.
Muy bien, Tania, gracias.
Did you hear her? Ask him if he could hear you.
¿Me puede escuchar?
Muy poco, pero sí le escucho.
Very little, but I can hear you.
Tell Mr. Quinones he has a right to remain silent.
Señor Quiñones, tiene derecho a permanecer en silencio.
He has a right to have an attorney.
Tiene derecho a tener un abogado.
He has a right to have one appointed if he can't afford one.
Se le puede asignar un abogado si no puede pagar por uno.
He has a right to make the state of Ohio prove the charges beyond a reasonable doubt.
Tiene derecho a que el Estado de Ohio pruebe sin causa razonable.
Does he understand those rights?
¿Usted entiende esos derechos?
Sí.
Yes.
Tell him he's charged with obstructing justice.
Su cargo es por obstrucción de una orden.
The state alleges that on June 15th, he prevented a public official in doing their official duty.
Usted el 15 de junio previno que un oficial público hiciera su labor.
The affidavit says he failed to provide information about his driver's license and ability to drive to the officer.
La declaración jurada dice que usted falló en proporcionar información de su licencia de manejo al oficial.
Does he understand that charge?
¿Entiende usted ese cargo?
Sí, me preguntó por licencia oficial y le dije que tenía de Guatemala, pero ya estaba vencida.
Yes, he asked me if I had a driver's license. I told him that I had a Guatemala driver's license, but it was expired.
Does he wish to have an attorney?
¿Desea usted tener un abogado?
No me queda claro la acusación de obstrucción. En cuanto al policía, yo salí de la gasolinera, estaba parqueado al contrario. Ya cuando yo di la vuelta, se me pegó por atrás y me paró. Pero no llevaba la sirena puesta, solo llevaba luces. Cuando vi las luces pensé que era a mí, me parqué a un lado. Pero me dijo que porque yo no había visto un triángulo que hay de señal que me hace hacer una espera antes de ir a mi derecha. Y cuando yo volteé a ver el semáforo estaba en rojo, pero ese es el que para el tráfico que viene a mi izquierda. Entonces yo pude irme, porque ese es como, no es un stop, es un libre stop, un título de stop para ver si viene el carro o puedo irme.
That was a lot. What did he say?
No, the policeman told me after I went out of the gas station, he stopped me. He told me that I didn't see a sign to stop. When I saw the traffic light, I saw it was red, but he stopped me. That's it.
Okay, well, tell him that wasn't my question. I wanted to know if he wants a lawyer to represent him.
Esa no era mi pregunta. Quisiera saber si quiere tener a un abogado.
Sí.
Yes.
Yes.
Does he have a job and any income?
¿Tiene usted algún trabajo e ingreso?
Sí, yo trabajo en la construcción.
What does he do? Ask him what kind of job he does. Did you
¿Qué
say?
tipo de trabajo hace?
Oh, carpintería.
Painting.
Painting. Paid by the hour? How much per hour?
¿Dijo carpintería o pintura?
No, carpintería. Carpintería y varilla.
Ok, ¿cuánto gana la hora?
25.
Okay. So you're an architect carpentry and he gets $25 an hour.
How many hours a week is he working?
¿Cuántas horas a la semana trabaja?
10 y 8. A la semana son 58.
He
¿Puede
said
repetir, por favor?
58 horas en la semana. De lunes a sábado.
8 hours a week.
I'm sorry, could you repeat that?
Yes, 58 hours a week.
68?
5.
58, 58. Does he have any money saved?
¿Tiene usted ahorros?
No, muy poco. No tengo.
No, I don't.
Well, he's making $25 an hour and working 58 hours a week. I can't appoint a lawyer for him, he's making too much money.
Si usted gana $25 la hora y trabaja 58 horas a la semana, no puedo darle un abogado, gana mucho.
Ok, entonces no, es que yo tengo familia que mantener entrar en un proceso contra apelando contra la ley porque sé que no voy a ganar. Porque mi palabra contra ellos es muy pequeña. Ya.
Okay, I have a family to support. I don't have any option against law. I'm not going to win. My word against theirs is very small.
I'm going to direct this question to the prosecutor. Do you know, is there a holder on him?
I believe that there is, and that's based on the statement of the criminal affidavit by Deputy Atkins.
Okay.
So,
Well, as an assistant to the court, I'm going to go ahead and appoint Mr. Stratton.
Yes.
I don't know how far. I'm appointing, go ahead and you can tell him I'm appointing him a lawyer.
Okay. Le estoy asignando una abogado, el señor Stratton.
Okay. I am informed that there may be a holder against him by the United States government, and that could trump whatever I do. Can you tell that?
Quiero informarle que puede ser que usted tenga una retención de parte del gobierno de Estados Unidos y eso no cambia lo que yo haga.
Oh, solo quiero que dígale que no sé qué proceso sea, porque, ¿me entiende? Yo soy un inmigrante, esa es la verdad, no tengo derecho a apelar algo que me están acusando.
I don't know what is the process. I am an immigrant. I don't have the right to appeal.
Okay, that's what we'll do.
Is there a recommendation on bond, Mr. Hill?
Your Honor, if there is an ICE holder, we would like any bond to have the condition that he could be turned over to ICE. I don't know if that's even required in order for them to do that, but so in lieu of that, we would ask for a $5,000 cash surety bond. But they could take him, and if they do, then they probably will.
ICE does what ICE wants to do, you know, contrary to what the court tells them to do. Your Honor, I mean, as an ICE detainer, I think the state would, they haven't committed to this, but I believe the state, if he does get picked up by ICE, will eventually dismiss this case.
I would say that's probably the case.
Okay. I'm going to set bond, you can tell him that I'm setting his bond at $5,000, cash or surety, that it's subject, if there is an ICE detainer, then even if he posts the bond, he won't be released. And my bond will be subject to their detainer. If they wish to take him, then they can. They don't have to abide by the state court's rules. So, if you would tell me that.
Thank you. Voy a establecer una fianza de $5,000 en efectivo o garantizada, sujeta a una retención de parte de inmigración. Ellos pueden venir a recogerlo en caso de que usted la pague si usted tiene la retención. Mi fianza está sujeta a la detención de ellos, ya que ellos no están obligados a seguir o obedecer las reglas del Tribunal Estatal.
Your Honor, I just asked we set this for Friday. If we recall, the Turkish gentleman we had was picked up within a couple of days, so this probably be resolved by Friday.
I'm going to set Mr. Quinano's case for another hearing Friday, this coming Friday, June 20th. And his lawyer will be here, and we'll see what happens in the intervening time, whether he is picked up by ICE or not between now and Friday. So please tell him that.
Ok. Vamos a tener una audiencia el viernes 20 de junio aquí mismo para ver qué es lo que pasa, para ver si lo recogen de parte de inmigración de aquí al viernes.
Ok, sí, lo de la fianza no podría pagarla, es lo que quiero aclarar de una vez.
Okay, I wouldn't be able to pay for the bond.
As I understand that, he's saying he can't post the bond anyway.
Exactly, he cannot.
I would ask that she explain again to him that there is an ICE holder, that bond really is irrelevant in this case.
Okay, his attorney wants me to have you explain to him that even if he posted the bond, if ICE has a holder on him, he wouldn't be able to get out.
Thank you. Su abogado quiere que le explique que incluso si usted paga por la fianza, usted no va a poder salir.
Okay.
Okay.
All right. I think he understands this. Okay, his case will be rescheduled for Friday. If he's still in custody, then we'll figure out how we're going to go forward.
Yep. All right, thank you, Your Honor.
All right, thank you, ma'am.
Thank you for using our services. Have a nice day.
You too.
Finish with the Lawrence County Jail, Your Honor.
Okay, we're finished up at the jail.
State of Ohio versus Cody McDonald, case number CRB 25-190, CRB 13-338, CRB 12-1113.
Your Honor, if I may, I had to call up. This is the one Mr. Major talked to you about Friday, and we just need to put it on record to take the ankle monitor off.
Okay. Okay, on Cody McDonald, he has an ankle monitor on. He's not set for a review hearing until July 28th. I'm going to order today that his ankle monitor be removed so that we can figure it out, free it up for other people that are in jail that need treatment. He's in treatment at Bethesda.
And it was agreed upon by Bethesda.
Yes. So they'll probably have to take him to adult probation. Yes. Okay, we'll keep the same review here in July 28th.
State of Ohio recalls Polly Elkins, case number CRB 24-387A and B, CRB 23-342.
Your Honor, if I may, she's the one that called Mr. Major this morning about her car broke down. She was in community service Saturday.
Okay.
She's never made it in, Your Honor.
Okay, she's got 7 days to get in before more issues.
She did ask me on the phone if she didn't make it when the next court hearing was. I told her Friday, so.
Okay.
State of Ohio versus Richard Sloan, case number CRB 14-630. Set for sentencing, Your Honor.
Richard Sloan set for sentencing. He has bond up, that's why it's coming on sentencing docket. And it looks like we go through this every time, he doesn't show up. Hey, is this Richard Sloan? Are you Richard Slime? Oh, okay. Richard Slime has failed to appear. I'll let Mr. Sauer know he's failed to appear. Said bond forfeiture for July 7th.
You know, I think the clerk has a question on that.
I'm doing sorry. He did go out there and pay everything.
Okay.
Can we just do that entry?
Yeah.
State of Ohio versus Raymond Wall. Case number TRD 23530, A, B, and C.
All right, this is Raymond Wall. He's got a bond up now with Mr. Sowers. He has appeared. And this is an old 23 case. So I don't think you've ever been arraigned on this, Mr. Wall. Doesn't look like it. Case number is 23530, A, B, and C. It's a driving under suspension, driving outside your lane, and distracted driving. So the state's alleging that on May the 9th of 2023 at 8:29 p.m. in Union Township, you were driving a vehicle with a suspended license. This is an unclassified misdemeanor, maximum penalty 500 hours community service, $1,000 fine. And that you drove outside your lane, that's a minor misdemeanor, maximum penalty $150 fine. And that you were a distracted driver, that's a $150 maximum penalty. And it looks like there was a one-vehicle car crash here, that you failed to appear at traffic court on May 23rd of 2023. And a warrant got issued because of that, and that you got picked up on the warrant and posted a bond through Mr. Sowers on the 15th, yesterday, June 15th. Do you understand the charge, sir?
Yes, sir.
How do you plead to it?
Guilty.
Let me read if there's a report here from the officers. There is a crash report, but it looks like it was a one-vehicle crash, just your vehicle. It says Unit 1 Southeast on State Route 775, drove off the right side of the road and struck a fence. No proof of insurance. Did you have insurance?
That wasn't in my truck. It was just a farm truck.
So was there damage to somebody else's property?
No, the fence was already tore down.
What
Most
about
of it.
the vehicle? Was the vehicle torn up?
No, they still drove it.
Let's see. Well, it says fence struck, and let's see what it says. The vehicle was owned by Richard Ramey of Ironton, is that right? Is he related to you, or?
No, just somebody they got the truck off of.
Well, what I think we probably need to do is have the prosecutor contact Mr. Ramey and see, because it's not showing proof of insurance, if there's any claim damages, and then there's also, I don't know if there's any indication on the fence. It says there was a fence. Oh, now I'm looking at the report. And it actually lists another person's name. Gage Adams was on the scene, advised he had just bought the truck from Richard Ramey, who was the register there. So there's going to be issues on that if there's any restitution. I don't see any listing for anybody that was under the fence. So I'm going to give the prosecutor a chance to try to contact Ramey and, was it Adams, I think? See if they, either one claim that they're owed any money for damages. And come back for a sentencing hearing. So we'll set it maybe a month out. Is that enough time, Mr. Hill?
Yes, and I don't know if we'll be able to find our file or just have to make a copy of the court's file.
It's 23-530 was the file for the case number. I'll set it for July 25th, more than a month. July 25th for sentencing. Issue is restitution. And that'll be at 10 o'clock on July 25th. And your bonds continue. You've got a bond up now. Okay, be back here on July 25th at 10 o'clock and we'll do sentencing. I want to hear anybody claims they're owed money for damage to either the fence or the vehicle. I'll let Mr. Sowers know you showed up.
Thank you, sir.
You are. Court's adjourned.